at the Ministry of Justice. I'm sure the Permanent Secretary won't be offended to know that I think most of our questions will be directed towards the Lord Chancellor today, but it's very good to have you here. It's the first time again that you've been in front of the committee. Lord Chancellor, I think you're going to make a short opening statement, and before I go on to that, we have to make our declarations of interest, so we will do that beginning with Sir Ashley Fox.
Good afternoon, Ashley Fox, Member for Bridgewater. My interests are as declared.
Good afternoon, Neil Shastri-Hurst, Member for Solihull West and Shirley. In addition to my interests as declared on the register, I'm a practising barrister who holds a current practising certificate with Bar Council, and I'm an associate tenant of Number 5 Chambers.
Good afternoon, I'm Warren Digges. I'm Member of Parliament in Wolverhampton West. I'm a solicitor but not practising. I'm a member of the GMB Trade Union Executive Council and various APPGs.
Alex Slaughter, I'm the MP for Hammersmith, chair of the committee. I'm a non-practising barrister. I'm a member of the GMB and Unite Trade Unions and the patron of two justice-related charities, the Upper Room and Hammersmith Fulham Law Centre.
Sarah Russell, solicitor specialising in employment law. Prior to arriving here, I'm on various APPGs, as you would imagine, and a member of various trade unions. I chair the Access, or co-chair the Access to Justice APPG.
Good afternoon, Pam Cox. I'm the Member of Parliament for Colchester. My interests are as declared on the register. I chair the APPG Penal Affairs.
Good afternoon, Vicky Slade, MP for Mid Dorset and North Poole. Interests as declared, but none relevant, just as a person who's been involved with the system on the right side. Just clarify.
I'm Tessa Munt. I'm the member for Wells and Mendip Hills in Somerset. All my interests are declared on the register, but I also want to point out I'm Vice Chair and a Director of Whistleblowers UK, which is a non-profit making organisation, and I'm Vice Chair to Pam's APPG on Penal Affairs, amongst other things. Those are the most relevant. Thank you.
I'm Tony Vaughan, the MP for Folkestone and Hythe. I'm a practising barrister, also with a valid practising certificate. I'm an associate tenant at Doughty Street Chambers, and I draw attention to my register of interests.
Thank you very much. So, Lord Chancellor, over to you.
Well, thank you very much, and this is my first opportunity to appear before the Select Committee, and I thank the Select Committee for its work to date, and I did take the opportunity to look at the video of the previous Lord Chancellor just a year ago. The committee will know that I'm not new to the justice issues. I was under Charlie Faulkner, responsible for legal aid in the old Department for Constitutional Affairs. I led the Lammy review, which was commissioned by David Cameron and Michael Gove at the time into disproportionality. I shadowed this brief, and it's a great privilege to be in this brief at this time. You will know from testimony and your own inquiries over the last 18 months or so that the government inherited two crises effectively. One was a prisons crisis, a capacity crisis, in which we had to act, and indeed now we have the sentencing bill going through, which will substantially alleviate that crisis. And then, of course, we've got the backlog crisis in our courts. I sometimes think we should describe that as a waiting list crisis, really, so the public can fully understand those who aren't in the criminal justice system. And I suspect some of your questions will pertain to the courts bill, which will come forward next year to deal with that crisis. But I'm very pleased that we've been able to put more money into legal aid, particularly for criminal barristers, for solicitors, for immigration, for housing, that we are also investing in our prison system. There is a lot to do. This is an area that really suffered hugely during the years of austerity. Not everyone sees inside a prison, but our prisons, as you will know, are in a dire state. We need to invest in staff, we need to invest in technology. There is much to do, but it's important in investing that 4.7 billion that we deliver those 14,000 prison places by 2031 to alleviate pressure, of course, in the estate as the sentencing bill comes into act, that we also continue to deal with foreign national offenders, which is a subject that the public care a lot about, and that over the course of this next period that we uplift probation particularly, and the 700 million in the spending review going into probation to get probation back to where it should be is essential, and that's why I made probation my first visit as Lord Chancellor particularly. I look forward to your questions, but the theme that I keep returning to is telling a bigger story about justice. Justice is not just about criminal justice. We also have our civil courts, 47 billion contribution from legal services to GDP in this country, which is hugely important in terms of growth, and to ensure that the system is modernised over this next decade, digital being at the heart of that in the prison service, absolutely in our courts, and right across the system to alleviate some of the pressures that our probation officers are facing at this time.
Thank you very much. And the committee takes your point, and we do a lot of work on civil, family and other forms of justice. But a lot of the questions, we will be touching on those this afternoon, a lot of the questions this afternoon will be around criminal justice, in particular the part one of the Leverson review and the government's response to that on releases of prisoners and on the probation service, which you mentioned. I should perhaps also add that we wrote to you and you kindly replied onto a number of detailed questions in relation to the matters concerning jury trials and related matters from Leverson, and that has just been published online. It answers some of our questions, but thankfully for the benefit this afternoon, not all of them. So I'm going to begin by asking a few questions on Leverson, and then my colleagues will come in as they wish. The first point that occurred to us is, has there been a formal response to Leverson? Now that's a very substantial piece of work, 388 pages. And we know obviously some of the things the government has said that it either adopts or goes further than or doesn't comment on. But is there going to be a formal response? And the second part of that question would be, you mentioned legislations and a court's bill. What needs to go into that bill, and when do we expect to see that bill?
There will be a formal response in the spring. It's my intention to come forward with a courts bill and legislation also in the spring. And I know that this committee is also focused on the modelling that sits behind where we have come to. And of course, I want to assure the committee that there will be the proper scrutiny when we do get to publishing a bill in terms of the impact assessment, both economic and the qualities that understandably parliamentarians will want to scrutinise and understand. So I have those three things to do. Alongside that, I know this committee will understand that I will be settling the Concordat with the Lady Chief Justice, which effectively also is pertinent to some of that modelling and to, as we draft legislation and both invest and reform at the same time.
Yes, we've had Leverson for some months now. We're talking about a response and a bill in the spring. I don't know if you can be any more specific than that, because there's clearly, to make some of the suggestions that you have to changes in mode of trial, powers of magistrates, judges sitting alone, you must have done some number crunching, you must have that information available. Why can't you publish that now?
Some of those numbers will actually relate to where we come out in the Concordat process, both in terms of investment in sitting days and where we end up, and therefore I'm not able to publish the modelling now. The modelling is an ongoing process, as you would expect. I indicated the landing spot in my statement a couple of weeks ago to indicate where the government was. We will be coming forward with a bill, and the detailed work is going on as we speak, and some of that detailed work, of course, involves work with the judiciary.
Do you know when part 2 of Leverson is going to be published? Will your response deal with that as well, and will the legislation deal with that as well?
Sir Brian has indicated that he expects to produce his response also in the spring, so the spring will be very busy. Part of the reason why it was determined to have, if you like, part 1, which is the reform which will require legislation, and part 2, which is really about processes and efficiency, which is unlikely to require legislation, is that we could get on with both, if you like, at the same time. But we will obviously, we are very much in the hands of Parliament once we introduce the bill and how long it takes to pass through the House. So I don't anticipate that Leverson 2 will require legislation. I think it will be processes that we can get on with, and we will need to consider that carefully. So I'm not anticipating a response immediately to Leverson Part 2.
Where do we look now? Spring, we know, is a movable feast, a movable season in political terms. Where do we go now to find out exactly what the government is proposing to do? Because it's a subject of great interest to the public and to politicians now, and we're sort of reliant on individual statements and answers to questions and things of that nature. That doesn't seem satisfactory for something as substantial as this.
Well, look, I recognise the need for this committee to be able to scrutinise, and I will reflect on how I can support the committee in that scrutiny. And it may be that there's a pre-legislative way in which the committee can get on with its important work. I know that the Chair will recognise that it's not unusual for government to make a statement, and indeed if we come forward with legislation in the spring, that will be still in this session of Parliament and pretty early for the government to come forward with that legislation. And that legislation will, as I've said, have the impact statements, and that will be subject to a lot of scrutiny, including by this committee.
And do you expect the bill to become law, presumably not in this session of Parliament, in the next session, before the end of the year? When will the measures in the bill take effect?
Well, it's my hope that the bill gets royal assent by the end of next year. That is, of course, my hope, and that is why I want to bring forward the bill in the spring, because that's how we get the maximum benefit of those reforms. Effectively, the backlog will continue to go up, even if we're getting on with implementing Part 2 of Sir Brian Leverson's work, even notwithstanding the fact, and we'll talk further about this no doubt, that I want to continue to invest in sitting days. So it's not until we get this legislation, in fact, that we'll be able to be doing all 3 of those things: investment, reform and modernisation.
You're talking about substantial changes to mode of trial, restriction of jury trial, substantial increase in magistrate sentencing powers, judges sitting alone, not even with magistrates alongside them. Would you be making any or all of those changes were it not for the backlog?
I think that's a very good question. Modernisation is required anyway. Let's put the backlog to one side, because when we look at the trends, they are worrying. We've got trial either way offences in the magistrates' court taking longer. We've got trials taking longer. We've got police arresting more, up 10%. Colleagues who are very experienced around this room recognise big innovations in policing and in investigations, DNA evidence, phenotype evidence within that DNA evidence, CCTV, the complexity of data and systems, all of that leading to lengthy trials. And so I do believe that the time has come to modernise a criminal court system that has effectively not been modernised since 1971, and that was the year before I was born. And so, yes, we do have to deal with the backlog, and it's 78,000 now. It will be over 100,000 by 2028-29 if we did nothing, and heading in the wrong direction. But frankly, because of what's happening, and indeed this place is legislating more, historic crimes are driving arrests. There's complexity with some of the sexual offences that this House has put onto the statute book. All of that requires, I believe, some reform to the criminal justice system.
So you see, I think it was almost a yes or no question.
Sorry,
and it's the answer.
I wanted to give you this.
It's the answer, yes, even if the backlog was at a sustainable level, that you will still be looking to make some of these changes, restrictions of jury trials, not allowing a rehearing from a magistrate's decision. There's significant changes in the way the system is operated, which are restricting in terms of the way the criminal justice system operates. And you're saying you would be going ahead with those in any event?
Yes.
There are several ways in which you can tackle the backlog. We can become more efficient, you can put more money in, or you can make the changes that you're proposing. Now, I don't know whether those are all worked out, but in the letter you sent to me last night, you say the open case log will be over 116,000 cases in our central scenario by June 2029, without taking further action, and over 125,000 cases in our high scenario, compared to around 78,000 currently. I'm assuming it doesn't say so in terms that is if you do nothing.
That's right.
If you do nothing, those are the sort of levels that it will rise to over that period of time. Now, clearly, you could have pushed ahead with what additional resources you can put in, sitting days, for example, repairing courts so that more courts can be used. You could make the system more efficient. You could make prison transport more efficient so that there weren't so many delays in dealing with prisoners in custody. Before you had to make these controversial, substantial and difficult, requiring legislative change. So why didn't you take that approach?
Well, I recognise the question, and we do have to do it. Sir Brian concluded, and I accept his judgment and his conclusions, that yes, efficiencies were important, but they would not be sufficient. And let's just step back and understand why they would not be sufficient. One is...
So I'm sorry to interrupt you, but I think what we're looking for is figures. So to know what the backlog would be if you just did the mode of trial and other changes, what would the backlog be before you put any efficiency measures or extra funding in? Can you break down how that backlog divides amongst those various cures?
I don't think it's not as straightforward as that. One, because we must let Brian do his work. But let me just come back to what we're really saying. Running a Crown Court trial is a bit like running an operation in a big hospital. It requires more than just the judge and the jury. It requires barristers, and we have, as you know, got a real problem with the pipeline of criminal barristers, and that's why I made the announcement that I made. It will take time for those barristers to come on stream. It requires courtrooms, and this committee has taken an interest in real maintenance issues. We have found extra money, but again, restoring our courts to where they were, given that they were languishing for 14 years, will also take time. Victims can't wait and shouldn't have to wait. And that's why Brian concluded that, yes, we must deal with those efficiencies, but we also have to act. And when we look at the cases vacated, when we look at the cases that are effectively unable to go forward, a part of those are related to efficiency, but some of those are also related to how the process is working between the magistrates and the Crown Court. And so the judgment that Sir Brian takes, and I accept that he's right in this, was could our magistrates do more? Should we still have the right to elect? And there are decisions that we've made in terms of mode of trial. And effectively, of the 3% of Crown Court cases that go forward, towards the bottom end of that, between the magistrates and up to 3 years, are we content for a shoplifting case or for a driving without insurance? Are we content for a case like that to be before a single judge? And that is the balance of judgment that I have taken.
I'm going to pause there because I know a number of colleagues want to come in, so I'll start with Neil.
Thank you very much, Chair. Lord Chancellor, I'd like to come back